the complex landscape of legal systems, where justice is often envisioned as a balanced scale, Marcus's story unfolds a disquieting truth. Even the most noble principles can be eroded by hidden biases. It is not merely a tale of a man wrongly accused, but an indictment of the unseen strings that manipulate judicial proceedings, twisting outcomes and undermining faith in its impartiality. The rich aroma of freshly brewed coffee filled Marcus' apartment on that crisp Tuesday morning, a stark contrast to the bitter chill that would soon engulf his life. In his mid-30s, Marcus was at the peak of his career, a brilliant legal scholar in Willow Creek, Ohio, renowned for his meticulous research into systemic bias within the very justice system he so deeply respected. He was on the cusp of publishing groundbreaking work, a voice of clarity aiming to shed light on complex legal shadows. His days were a quiet symphony of lectures, academic debates, and the profound satisfaction of dissecting intricate legal puzzles. But then the melody abruptly stopped. Without a single warning note, his world shattered. The knock on the door came early, insistent. Officers, grim-faced and unyielding, presented a warrant chillingly formal. Marcus, the man who wrote about justice, was suddenly living a terrifying real-life legal nightmare. He was arrested, indicted for a high-profile white-collar crime he absolutely did not commit. The media descended like vultures, their headlines screaming accusations, painting him as a deceptive mastermind. One moment, he was dissecting legal theory in hallowed university halls. The next, he was thrust into the unforgiving spotlight, a public pariah, his life's work twisted into a cruel irony. How could this be happening? In America, we are taught to hold sacred the promise of the Sixth Amendment, the right to a fair trial, to a jury of our peers, a true reflection of the community. This isn't just a legal concept, it's the bedrock of our justice system, the ultimate safeguard against arbitrary power. Marcus, with his encyclopedic knowledge of constitutional law, clung to this ideal. His seasoned public defender, Ms. Evans, her eyes etched with the weariness of countless courtroom battles, but still gleaming with a fierce, quiet dedication, believed in it too. In those initial, chaotic days, they held on to the conviction that once the facts were laid bare, once an impartial jury heard his story, the undeniable truth would prevail. What Marcus didn't know was that the very first thread of injustice, unseen and insidious, was already being spun, not in the shadows, but right there, in the brightly lit halls of justice. As voir dire began the meticulous, supposedly unbiased process of selecting the jury, a subtle, unsettling pattern began to emerge. A pattern that would slowly unravel his hope and push him to confront the hidden prejudices lurking beneath the surface of the law. This wasn't just about his innocence, it was about the integrity of justice itself. The courtroom was a study in sterile formality. Polished wood gleamed under the harsh fluorescent lights, the air thick with unspoken tension. For days, potential jurors cycled through, a parade of diverse faces, each one a potential arbiter of Marcus's fate. Marcus sat beside Ms. Evans, his scholar's mind diligently observing, analyzing every nuance, every raised eyebrow, every dismissive gesture from the prosecution. Ms. Evans, a veteran of these legal skirmishes, focused on finding the truly impartial, those who could look beyond the sensational headlines and see Marcus, the man, not just the accused. The process is called voir dire, French for to speak the truth, and on paper, it's about fairness. Lawyers from both sides ask questions, trying to weed out biases. They also wield a powerful, often ambiguous tool, peremptory challenges. This means they can dismiss a certain number of potential jurors without giving any reason at all. On paper, it's about shaping a balanced jury. In practice, as Marcus was about to discover, it's a legal trapdoor, a mechanism that can quietly, systemically tilt the scales of justice. As the days wore on, a chilling pattern began to emerge, subtle at first, then starkly, terrifyingly clear. Marcus, with his deep understanding of statistics and systemic inequities, was the first to see it. He watched, helpless, as qualified black potential jurors, regardless of their calm demeanor, their strong professional backgrounds, or their seemingly open-minded answers, were systematically dismissed by the prosecution. There was Mrs. Albright, a retired social worker. She spoke eloquently about her belief in fairness and community service. Dismissed. The reason? Questionable body language. Then came Mr. Henderson, a union representative, a homeowner, articulate about civic duty, confirming he could serve without issue. He too was gone for a vague answer about time commitment, despite his explicit assurance. It happened again and again. A promising black juror would appear, only to be ushered out for a reason so flimsy it felt like a deliberate insult, a coded message in plain sight. A cold wave of dread washed over Marcus. He began to count, to cross-section their profiles, to replay the flimsy excuses in his mind. It wasn't random. It was a pattern, subtle but undeniable, like an invisible thread pulling tighter and tighter around him. He leaned over to Miss Evans, his voice tight. "Did you see that, Miss Evans? The pattern. It's too consistent." She nodded slowly, her lips pressed into a thin line. She'd seen it before, countless times. This was the silent, insidious power of the peremptory challenge. Decades ago, the Supreme Court, in the landmark case of Batson versus Kentucky, tried to put a stop to this. They ruled that lawyers couldn't use peremptory challenges to dismiss jurors based on race. If a defendant could show a pattern of racial exclusion, the prosecutor had to provide a race numeral reason. Sounds fair, right? A legal check on an unjust power. But in practice, those race numeral reasons often became a flimsy veil, an easy excuse. Seemed distracted. Expressed skepticism about authority. Had a distant relative with a minor offense. These were the phrases Marcus and Ms. Evans heard, over and over, as qualified black citizens were systematically ushered out of the jury pool. The courtroom, meant to be a beacon of impartiality, was beginning to feel like a suffocating cage. Marcus knew they had to fight this, not just for his freedom, but for the very soul of justice itself. They would file a Batson challenge, a legal battle within his own trial. "We have to challenge this, Miss Evans. It's blatant." Marcus's voice was firm, an academic's conviction hardening into a defendant's desperate plea. Mrs. Evans ran a hand through her thinning hair, a weary gesture. "I know, Marcus. Believe me, I see it. But winning a Batson challenge is like trying to catch smoke. You have to prove intent, that they meant to discriminate. Prosecutors are masters at finding those race numeral reasons. Most judges, well, they'd rather not rock the boat." She'd seen too many of these battles lost, the system shrugging off cries of foul play. The legal standard for proving such bias was notoriously, heartbreakingly high. But Marcus, fueled by the cold fire of injustice and his deep understanding of legal theory, wouldn't back down. "This isn't just my case anymore, Miss Evans. This is the system revealing its true colors. If we don't fight it here, now, then what's the point of any of it?" His resolve was infectious. Miss Evans, a glint of the old fighter returning to her eyes, agreed. They would proceed. The Batson hearing was a stark, almost theatrical showdown within the trial itself. Miss Evans, with surgical precision, presented their case. She laid out the numbers, the stark statistical disparity between the dismissal rates of black and white potential jurors. She painstakingly replayed the seemingly innocuous reasons given for each dismissal, highlighting their flimsiness when compared to the strong qualifications of the dismissed individuals. She painted a picture not just of an anomaly, but of a pattern. "Your Honor," she concluded, her voice steady, "the pattern is clear. The reasons offered are pretexts. My client is being denied a jury of his peers simply because of his race, and the spirit of justice demands this court intervene." The prosecutor, however, was unfazed. He stood confidently, his demeanor unyielding. He calmly, logically reiterated his race-neutral explanations for each dismissal. "We're looking for jurors who can focus solely on the evidence, Your Honor, free from any extraneous leanings. My challenges were based purely on their demeanor, their responses to specific questions, and their ability to commit fully to a lengthy trial. Race played absolutely no part in my decision-making." He even subtly implied that the defense was merely playing the race card, trying to manipulate the proceedings with emotional appeals. The judge, a figure of solemn authority perched above them, listened intently, his face unreadable. He had to weigh the appearance of discrimination against the excruciating difficulty of proving a prosecutor's true intent. Every lawyer in the room knew it was an uphill battle. Then came the ruling. "The court finds," the judge began, his voice devoid of emotion, "that while the defense has presented concerns regarding the racial composition of the jury pool, the prosecution has provided facially neutral reasons for its peremptory challenges. While the court acknowledges the sensitivities surrounding these issues, the defense has not met the high burden of proving purposeful discrimination under the current legal standard." A cold wave washed over Marcus, but it wasn't despair. It was a profound, chilling clarity. The words echoed, but it was the silence that followed, the finality of it, that hit him hardest. The door to a truly fair jury had just slammed shut. Ms. Evans's shoulders slumped almost imperceptibly, a familiar defeat etched on her face. They had fought, they had exposed the pattern, but the system had held firm. The consequence was immediate and devastating. The chosen jury, now seated in the box, was notably lacking in diversity. Marcus looked at their faces, almost uniformly white, many older, some with subtle expressions that felt distant, uncomprehending. He knew, with a chilling certainty, that his fate wasn't just in the hands of the law, but in the hands of a jury that didn't truly reflect his community or his lived experience, a jury that might be less inclined to question authority, less likely to understand the nuances of systemic injustices. The trial proceeded, but for Marcus it was already tainted. He and Ms. Evans would fight tooth and nail, presenting every piece of evidence, dissecting every prosecutorial argument, but the subtle, insidious bias of that jury, formed through those unseen strings of selection, created an uphill battle he might never win. He was innocent, but in a courtroom where the very foundation of fairness had been compromised, innocence alone might not be enough. The verdict, when it came, felt inevitable. It was a punch to the gut, but it also ignited a new kind of fire within Marcus, a fire that would not be extinguished. The trial, despite Ms. Evans's brilliant defense, felt like a slow, agonizing march toward a predetermined outcome. The prosecution paraded its witnesses, weaving a web of circumstantial evidence. Marcus watched dispassionately at times, dissecting their arguments just as his own research had taught him to observe flawed systems. He knew their case was weak, their evidence thin, but he also knew the jury, subtly shaped by those dismissive choices during voir dire, was unlikely to scrutinize with true impartiality. Then came the day of the verdict. The air in the courtroom was impossibly thick. Marcus stood, a quiet strength in his posture, even as his heart hammered against his ribs. The foreman read the words, cold and clinical, yet devastating in their finality. Guilty. A collective gasp rippled through the gallery. The word echoed, but in Marcus's mind, it was merely the opening salvo of a much larger war. It wasn't despair that settled in his gut, but a cold, burning resolve. This was not the end. From behind prison walls, the fight transformed. Marcus, the legal scholar, became the ultimate student of his own injustice. He spent countless hours poring over legal texts, his mind sharper than ever, driven by a singular purpose: to find a loophole, a mechanism, to expose the unseen strings that had tightened around him. Ms. Evans remained a staunch ally, visiting often, bringing him case files, believing in his innocence as fiercely as he did. Then, a flicker of hope appeared on the distant horizon. While Marcus was awaiting his appeal, the state of Ohio, influenced by mounting public pressure and academic studies, had quietly passed a new groundbreaking piece of legislation, the Willow Creek Racial Justice Review Act, WCRJ-RA. This wasn't a standard appeal. This act allowed individuals to petition for a post-conviction review if they could prove that systemic racial bias had influenced the outcome of their trial, specifically including the jury selection process. Marcus's mind seized on it. This wasn't about a single biased juror or one unethical prosecutor. This was about the system itself. His own case, he realized, was not an isolated incident, but a symptom of a deeper institutional flaw. This was his path, his last, desperate chance. Together, Marcus and Ms. Evans began an arduous, painstaking process. They initiated a massive undertaking, pouring through years, nearly a decade, of court records in Willow Creek. They analyzed hundreds of voir dire transcripts, dissecting every question, every answer, every peremptory challenge made by prosecutors. It was a forensic examination of justice itself, a hunt for patterns hidden in plain sight. And then, the truth began to emerge. It began as a whisper in the data, then a murmur, until it roared into an undeniable symphony of systemic bias. The data, cold and irrefutable, painted a horrifying picture. A widespread, systemic pattern of discriminatory, peremptory strikes against black jurors across numerous cases in Willow Creek's court system. They found internal memos with veiled language about profiling juror types that disproportionately affected minorities. They unearthed statistical analyses showing black jurors dismissed at 3, sometimes 4 times the rate of white jurors in similar cases, even when their responses to questions were virtually identical. The unseen strings were no longer invisible. They were laid bare by the raw, undeniable force of data, screaming from the spreadsheets and court documents. It wasn't just bad luck, it was a strategy, coded and concealed, that had quietly condemned countless others in Willow Creek. This discovery changed everything. It transformed Marcus's individual battle into a fight for a community, for a more just future. The stage was set for a final, pivotal hearing, not just for Marcus's freedom, but for the integrity of justice in Willow Creek. The Willow Creek Racial Justice Review Act, WCRJRA hearing, felt fundamentally different from Marcus's first trial. This wasn't about whether he had committed a crime, it was about whether the system itself had. The courtroom, usually a stage for individual guilt or innocence, was transformed into an arena for systemic accountability. Marcus, no longer merely a defendant, stood as a petitioner, an undeniable voice for justice, presenting the meticulous data he and Ms. Evans had painstakingly uncovered. Expert statisticians and legal scholars, many from his former university, testified. Their charts, their graphs, their irrefutable analyses laid bare the chilling patterns of bias that had permeated Willow Creek's jury selections for years. The focus now squarely fell on the hidden prejudice, the unseen strings that had manipulated countless fates. The tension was palpable, a heavy silence broken only by the sheer weight of the evidence. This time, there was no denying it. The numbers screamed. The judge, a different one this time, listened with a solemn, almost pained expression. Faced with such overwhelming empirical proof of systemic racial bias, the legal standard that had once protected the prosecution's flimsy excuses crumbled. The truth, backed by data, was simply too powerful to ignore. And then, the ruling came. The judge's voice, clear and firm, cut through the silence. The court finds that the petitioner, Marcus, has presented clear and convincing evidence that systemic racial bias tainted the jury selection process in his original trial. Therefore, his conviction is hereby overturned. The word overturned resonated differently this time. It wasn't just about his freedom, it was about a system acknowledging its profound failures. A collective exhale swept through the courtroom. Miss Evans gripped Marcus's arm, her eyes shining with unshed tears. After years, the truth had finally been heard. Marcus, the man accused, the scholar imprisoned, was free. His story is more than just one man's journey to vindication. It's a stark, powerful reminder that justice isn't a passive ideal. It's a continuous, arduous fight. Marcus's battle helped unravel the unseen strings in Willow Creek, exposing how subtle, ingrained biases can derail lives and undermine the very foundation of fairness. It teaches us the incredible power of persistence, the undeniable strength of knowledge, and the profound importance of holding our institutions accountable. For countless others, the fight continues, but Marcus's legacy, carved from resilience and intellect, stands as a beacon. It's a testament to the unseen battles waged in our courtrooms every day, a stark reminder that true justice isn't given, it's fought for, discovered, and fiercely protected. His victory wasn't just his own, it was a victory for every person who has ever felt the tightening grip of those unseen strings. If this story resonated with you, if it made you think, made you feel, then please hit that like button, share this video with someone who needs to hear this message, and subscribe to our channel for more tales that challenge, inspire, and remind us of the incredible human spirit. Your support helps us amplify these crucial stories. Thank you for listening.